I think we're now ready to resume. Mr. Hermer.
Thank you, my lord. I was setting out 7 features of the case, and I think I just finished on 4, which is the acknowledgement of numerous assessments by immigration officers that wrongly identify children as adults. So if I go to my 5th point, which is that since July 2014 and the coming into force of Section 5 of the Immigration Act of that year, there has been a statutory prohibition on the detention of children, irrespective as to whether or not an immigration officer has formed a view in compliance with the policy that their appearance and demeanour strongly suggest they're significantly over 18. And as I'm going to develop, this has transformed the legal significance of an erroneous age assessment performed by the officer under that policy. Whereas previously, the detention of a child would be lawful if an officer reasonably but wrongly believed they looked significantly over 18. Now the decision to treat as an adult will be unlawful and will lead to an unlawful act. And this might be, I hope, a convenient moment just to deal with the points arising out of questions from my Lord Reid and Lord Sales earlier as to, well, is there a tension between the prohibition contained in Schedule 2 as amended and other obligations that are brought into play or may be brought into play by the determination of the immigration officer under this policy? And the answer to that is no. And let me just give make three particular points. Firstly, it's not a determination by the immigration officer that a person is a child. Rather, it is simply that they cannot be treated as an adult for the purposes of detention. It's a middle ground status identified by Lady Hale in the Croydon case. Can I just give you the reference? It's paragraph 6 in her judgment at page 2204. So that's the first point. The second point, that within the immigration system and asylum system, it has no legal effect that bears upon any other statutory power or prohibition. We touched upon the 2002 Act because that was referred to in the Merton case in paragraph 1. I think there was a question from my Lord Reid as to whether or not there is a tension between a finding under the impugned policy and any relevant findings in that case. My Lord, that wouldn't arise. I mean, firstly, because of the first point I've made, but secondly, because the 2002 Act is only an obligation, gives rise only to an obligation to provide accommodation, or indeed under the 1999 Act, asylum support more generally, on an application by an individual, and on the application, a person has to assert that they are over 18. So you're never going to get into a position in which there is a conflict between the determination under this policy and powers and obligations under the 2002 Act. And thirdly, for the purposes of obligations on local authorities arising out of the Children's Act, the assessment of the immigration officer under this policy has no legal effect. The local authority is obliged to carry out its own age assessment, which will be a Merton compliant assessment. And the local authority has powers to accommodate in the interim whilst waiting for that assessment, other than on the Children's Act. So it wouldn't. I'm so sorry, my Lord.
Can you give us the details of the power to accommodate?
Yes, my Lord. Would my Lord forgive me if I don't have them to hand? But what we are anticipating would be helpful is if just simply a note that identifies those, no commentary, but just so that you have it. Of course, we entirely understand why the court raises that, but it's not a point that was taken against us. So we want to make sure that any answer I give the court is a comprehensive and accurate answer. So I hope I could be forgiven for dealing with it in that way. But that my third point on this reflects our understanding of the position. So that's my fifth point about the change in legal landscape introduced by the 2014 Act. which is a clear prohibition on detention of children in all circumstances. And then takes me to my 6th point, which is that there's no dispute that the unlawful detention caused by the policy can be for a very significant period of time. The months endured by the respondent in this case are not said to be atypical. And there's no automatic process of challenge. There's no automatic subsequent Merton assessment. That has to be asked for by the, in many cases, child who arrives unaccompanied and is placed within the detention system. And it's also acknowledged, indeed it's reflected in the policy, the new policy itself, that the experience of placing unaccompanied children in an adult detention system can be deeply damaging to their physical and mental health. And as the intervener sets out, between paragraphs 28 to 32 of its written case, CEF 147, there are further significant consequences detrimental to the child beyond the risk of detention if an incorrect assessment is carried out. So this is an exceptionally profound decision, or rather the decision has profound consequences for the individual who is subject to the decision. The 7th feature is one I've already alluded to in answer to a question from Lord Sales, which is just because it may be very difficult to decide to devise an age assessment process that removes all risk or removes it to levels that are considered legally acceptable, doesn't relieve the lawful obligation on the appellant to ensure that the policy strives to meet the statutory prohibition. And it is noteworthy, we say, that since the Court of Appeal, the revised policy, which does address the heart of the Court of Appeal's critique, which is no account for margin of error, does now address the margin of error. And we don't suggest that that current policy is unlawful, nor is there any suggestion that its application has led to unlawful detention of children. And equally, there's no evidence that the new policy has caused any difficulties for the appellant. For example, that it has led to an increase in numbers of people wrongly claiming to be children and an influx of adults into the local authority system. The new policy demonstrates that which the Court of Appeal thought likely, that guidance can be crafted that materially reduces the risk of unlawful outcomes to a legally acceptable level. Now, the appellant doesn't hide from any of this, but rather states that the impugned policy reflects the best attempt of the executive to address the difficulties inherent in the task of assessing the age of a person, whilst at the same time incorporating the other legitimate and competing demands that the Secretary of State has to bring into the balance. And this, they contend, is preeminently a matter for politicians, absent a mistake of law on the face of the policy. It's for politicians, not for judges. And if, in her judgment, it's preferable to return to the old policy, then even if, as she must accept it would lead to an increase in the unlawful detention of children. That's a matter for her, it is said, not for you. Now, in meeting that case, with my Lord's permission, I want to send out a response to grounds 1 and 2 as to how the claim falls to be analysed within Gillick terms, both ultra vires and rationality, and how there is no room, if that analysis is adopted, for the policy arguments advanced by my learned friend. And in order to demonstrate the unremarkable nature of this case and how it falls within both ultra vires and rationality, can I divide short submissions into 5 heads? Firstly, to look at the relevant statutory framework. Secondly, to look at the meaning and effect of the policy. Thirdly, to examine the public law grounds that arise when the policy is examined in the statutory context. Fourthly, the criterion for establishing illegality under ultra vires or rationality. Is it a test of real risk of more than a minimal of a legally significant outcome? And fifthly, the role of policy. I can do it quite briefly, if I may, start with statutory framework, which isn't really in dispute. Since 1991, since at least 1991, the appellant has published a policy on how she intended to exercise the broad powers of detention granted to her under Schedule 2 of the 1971 Act. Now, although these policies were initially published out of an implied duty to give guidance, and can I just give you the reference for that? It's Lord Dyson at paragraph 34 of Lumber, tab 57, EF 3545. This must have been put on a statutory footing in respect of children since the introduction of Section 55 of the Borders, Citizenship and Immigration Act of 2009. I'm going to show you that in a moment, but it may not make a difference because we don't understand the Secretary of State's case to say that a policy is, whether a policy comes from an implied statutory obligation or an express statutory duty makes a difference as to whether it is reviewable. So can I just quickly say why this must really, I'm so sorry, my Lord. Lord Sales.
Yeah, sorry. I was just looking at paragraph 35 in Lumber, page 3545. And there, Lord Dyson seems to be talking about having a policy to deal with aggression.
I'm so sorry, my Lord, I missed my...
Page 3545,
Yes.
Mr. Herbert.
Yes.
You referred this to paragraph 34.
Yes, my Lord.
And I think one needs to read it with 35. And in paragraph 35 in particular, Lord Dyson is talking about having a policy to deal with a statutory discretion. But might it not be said that we're not dealing with a discretion in this case? We're just dealing with a statutory rule that says if you're over 18, you can be detained.
Oh, my Lord, yes. I'm giving this, at the moment the historical overview. Prior to the 2014 Act, the Secretary of State enjoyed a very wide power indeed to detain. But what she's done since at least 1991 is set it out in terms how she was intending to exercise those powers.
Right.
So, which included, for example, that you would only detain children in exceptional circumstances. So the simple point I'm seeking to make now, I don't want to labour it, is that we've had a policy in place since 1991. Initially, that policy was promulgated in compliance with an implied statutory obligation to explain how the Secretary of State was going to exercise their broad powers. Since the introduction of the 2009 Act in respect of children, there's been an express statutory obligation to provide guidance. That was the simple point I was making. We were surprised that my learned friend, in answer to a question this morning, said that Section 55, this guidance wasn't pursuant to Section 55. Of course, it predates it, but in terms of the obligation to have guidance, if the court would be so kind as just to quickly look at Section 55, which you'll find at page 1934. You'll see from Section 55(1) that the Secretary of State is obliged to make arrangements under A, ensuring that the functions mentioned in subsection 2 are discharged, having regard to the need to safeguard and promote the welfare. Subsection 2B is that the functions referred to above are any function conferred by or virtue of the Immigration Act on an immigration officer. And we can see from subsection 3, a person exercising any of those functions must, in exercising the function, have regard to any guidance given to the person by the Secretary of State for the purposes of subsection 1.
Mr. Herbert, I'm so sorry, before you put it away, if we look at the duty in Section 55 1A, might it not be said that that's been complied with insofar as one's looking at the policy here? Because the policy guidance has had regard to the need to safeguard and promote the welfare of children by introducing the benefit of the doubt principle.
Yes, my Lord. And that's
so at the moment, I can't see why, or are you even saying that there's any breach of the obligation in section 55(1)(b). Sorry,
I'm not, my lord. I'm not contending that.
All right, thank you.
I was merely taking you to it, just so we can see as part of the statutory scheme that there is a statutory obligation to provide relevant guidance. It's not simply an implied statutory duty. That's the only purpose for which I was taking my lord to this. And my lord, the court's already been shown AA Afghanistan, where this court held prior to 2014 amendments, the court held that the policy was in conformity with section 55, and I'm not arguing section 55 point, the substantive section 55 point before this court. So I'm merely taking you to it to show that there is that the guidance that we are examining appears to be a guidance that the Secretary of State is obliged by statute to promulgate. No more, no less for those purposes. Now, notwithstanding that prior to 2014, the Secretary of State had a broad power to detain children, policy prior to 2014 was that she would only do so in exceptional circumstances. And prior to 2014, the relevant sections of the policy in respect of age assessment were designed to ensure that immigration officers only detained those that they reasonably considered to be adult. If the test for age assessment set out in the policy was applied correctly and in good faith, then a child could be lawfully detained if the officer reasonably but wrongly concluded that the child was an adult because they looked significantly over 18. That would have been entirely lawful. Now, that materially changed with the introduction of Section 5 of the 2014 Act, because as the Court of Appeal made plain in AA Sudan, which my learned friend expressly says is not challenged in this case, the effect of the amendment was to prohibit the detention of all unaccompanied minors, save in certain circumstances that are not relevant to this appeal. So at a stroke, the amendments transformed the consequence of a reasonable but wrong assessment from the undesirable to the unlawful. And the amendment consequently also transformed the nature and the significance of the function being exercised by an immigration officer when assessing age. He or she was no longer required to reach a reasonable view on the age of a disputed person, but the correct view. But while the relevant statutory tests change, the policy guiding the decision maker did not. The guidance drafted to aid the officer in reaching a reasonable view of age continued to apply without modification. All of that was the natural starting point for the Court of Appeal's analysis, correctly, that relevant statutory framework at the forefront of their judgment. See, for your note, paragraphs 9 to 11. Now, a number of things we say flow from that framework. Firstly, this is a clear statutory framework which permits a ready assessment of whether or not the guidance that purports to give effect to it is ultra or intra vires. It's not a case such as Gillick, in which there can be doubt as to whether there's a relevant statutory framework at all. Secondly, a statutory requirement that the policy must give effect to is also clear, and arguably so since AA Sudan, namely ensuring that no child is detained. Thirdly, the import of careful scrutiny as to whether that policy is intra or ultra vires of the statutory requirement it serves is obvious. The proper application of this policy is the means by which the Secretary of State ensures she's not breaking the law by detaining children without legal authority. That's the relevant statutory framework we submit. And I then turn to the meaning and effect of the policy itself. We've placed RAISI in the bundles, just for your note, it's tab 52, EF 3375. But I'm going to anticipate that the following three propositions are uncontroversial. Firstly, that the policy documents need to be given their ordinary meaning and not treated as if they were some form of statute. Secondly, the documents need to be read through the eyes of those who are intended to read and obey them. So we need to assess how they'd be read by an immigration officer who, on the agreed evidence, would have received no specific training in age assessment. It all needs to be factored in as to how they are read. As to lack of training, see paragraph 58 of the Court of Appeal, EF 1930. And thirdly, they, of course, need to be read in their proper context. So, of course, I accept that when we look at the impugned criteria C, it needs to be read in light of all the other materials on age assessment. Now, in our submission, it is clear that properly construed, the objective meaning of the words significantly over 18 means what the officer reasonably perceives to be significantly over 18. That could be 20, 21, or 22, or 23, or indeed above. The term significantly over 18 cannot be construed as imposing a hard-edged meaning of over 23, or some other age calibrated so as to ensure no children are wrongly assessed as adults. There is simply nothing in the language of the clause, nor in the accompanying policy documents, that would support any other reading. I beg your pardon, would support such a reading. And this, my lords, is how the court interpreted the policy. And can we just pick that up briefly? Starting with the Vice President of paragraph 65. I beg your pardon, page 195, electronic bundles. So we can see that his lordship said that both the policy documents, the EIG and assessing age, fall short of what is required in one crucial respect. They contain no recognition of just how unreliable the exercise of assessing age on the basis of appearance and demeanour is, and in consequence, how wide a margin is required. In truth, all the work is done by the single word significantly, but it's not a word which can be interpreted in, but that is a word that can be interpreted in many different ways, and its imprecision is not corrected simply by printing it in bold or undermining it. And then, obviously, I rely on the entirety of that paragraph, but just picking it up towards the end, only if the officer is made aware of the extent of the unreliability of the exercise, by reference to specific ages, can he or she make an informed decision about whether a claim to be under 18 is indeed obviously false. There's nothing of that kind. His lordship concluded in the policies. And Lord Justice Baker at page paragraph 100 to the same effect, page 203. His lordship said the fact that the initial assessment under criterion C includes demeanour as well as physical appearance does not materially strengthen the policy, since the assessment of demeanour is also carried out by visual observation alone. Similarly, I don't consider the phrase very strongly suggests materially reduces the risk of erroneous decision. Likewise, significantly over 18, that phrase is not further explained or defined in the policy. And then his lordship's comments on a second reading. And just for your note, Lord Justice Simon notes the imprecision. That's paragraph 97, page 202. Although, as we'll see, as my lord will already see, he takes a different view from the majority in respect to the updated policies. Now, my lords, we say a number of things flow from the meaning of criterion C, from the test of significantly over 18, when properly construed. Firstly, applying the policy as intended will mean that an immigration officer can properly conclude that a child's age and demeanour strongly suggest they are significantly over 18, because on visual assessment they can look anywhere between 20 and 23. So they will be presented with children who will look somewhere between 20 and 23, and the policy would seem to be enable them to deem them as adults. Secondly, if the immigration officer reaches this conclusion, they are obliged to treat the child as an adult. Can I just make that point rather than wading through the policy documents, just in the relevant extracts in the Court of Appeal judgment? So we can see this if the court would be so kind as to go to paragraph 25, which you'll find at page 181. And this is setting out the relevant extract from assessing age document before the upper tribunal. And you can see just from the very first paragraph, the applicant should, point would underline, should be treated as an adult if their physical appearance and demeanour very strongly suggest that they're significantly over 18. That language is actually tightened up in the subsequent version of assessing age. If we go to paragraph 28, page 183, but if you could just go to the top of 184, you'll see that it's now you must treat the claimant as an adult. Lord Sales, I'm sorry.
Yeah, I mean, it's really coming back to the same thing. This is dealing with a case where the official has no doubt as to the age. So they no doubt in their minds that the person is over 18. That being so, doesn't the statute require them to treat them in a particular way? What else could they do if they believe, all things considered, they've really thought about it very hard, that they're dealing with someone who is 18 or over, and the statute tells them how to deal with a person who's 18 or over? What else can they do but obey the statute?
Well, because the purpose of the policy and the guidance is to guide the decision maker in reaching the correct decision. And at the heart of our case is that the guidance that is given is capable of guiding the decision maker to the wrong decision, and the unlawful decision.
Yes, thank you.
So that's the second observation flowing from criterion C. The third.
Mr. Hammer.
Oh, I'm so sorry, Lord Briggs. I'm so sorry.
Mr. Hammond, you accept that for the purpose of understanding how this would all be understood and interpreted by the immigration officer, you've got to assume the officer conscientiously reads the whole of the policy.
Yes, my lord.
It's not a policy where one officer reads one bit and another officer reads another bit because they're doing slightly different jobs.
No, my lord, I accept that. Yes.
Right. So they would read a clear statement that the College of Pediatric Medicine reckons that an expert paediatrician may well make a 5-year margin of error from time to time.
Yes, my lord, I accept that's right.
And that there would be no rational basis for the reasonable immigration officer to think that they would perform significantly better than an experienced, skilled paediatrician.
My lord, I also accept that.
So why would not the concept of margin of error be firmly in their mind when deciding whether somebody in front of them appeared to be significantly over 18 in a policy where these criteria are simply meant to remove from the testing process someone about whose age there really isn't any doubt?
Yes. Well, my lord, I would respond to that, I'd say two things. I mean, firstly, it is one, without wishing to repeat the points I made before.
I've got those.
But they're properly construed. The reference to the caution that needs to be exercised when a paediatrician says somebody is 17 because there is a margin of error cannot be deemed to be, therefore, in the mind of the decision maker, where they're applying a different part of this policy document to look at age and demeanour. A fortiori, because of the passage that I took you to in 777, where their attention under the correct test, the actual test that they are applying, and there's an express reference to the unreliability or the of margins of error. So, my lord, it's an unrealistic, we would say, not least because these are untrained officers. They're given this document. They're not trained in it. They're given this document, the reference in it. And it wouldn't be right, we say, to latch onto one reference that's addressing a different issue and say that must therefore be a matter that's within the mind of the decision maker where he's addressing a different issue. So, of course, it's in the same document, but if we'd say construed in the real world, it's clearly not something that the decision maker is told they need to be taking into account at the point in which they are making the critical decision as far as this case is concerned. And it is, I hope I'm not thought I'm making a jury point when I reiterate, this has never been a point suggested by the Secretary of State, that somehow this test is incorporated because of this passage. And one would have thought that if it was incorporated in part of the test, and this was the experience of immigration officers, that would have been at the forefront of their submissions before the upper tribunal and the Court of Appeal, or indeed before this court. And so, of course, I can see that you can make that construction point, but it's not, would we say with the greatest respect, a realistic one in the circumstances. And particularly, one needs to be very careful, as we're reminded, not least in Munjaz, that in the context of this case, one needs to really apply anxious scrutiny to how we construe the document and how we construe what the meaning of the policy is in light of the context of deprivation of liberty. And it would be unfortunate and incorrect, we say, to latch on to something else in a document to construe another part of it.
Thank you.
The third point I was just going to make on construction is that the consequence of is it means that a consequence of it is it means a child is therefore liable to be detained. Somebody who looks 21, 22, 23 is liable to be detained, and that will be unarguably unlawful. So that then takes me to my third heading, which is what are the public law grounds flowing from that? And we say that once the meaning and effect of the policy are analysed in light of the statutory context and the meaning of the document, then the claim falls very comfortably within the confines of public law orthodoxy. And that's because the policy is capable of leading an immigration officer into unwittingly committing unlawful acts that are not simply not authorised in the statute, but are expressly prohibited in the statute. And that engages the various different ways that the House of Lords examines the legality of guidance in Gillick. Now, one complication of Gillick is that the members of the Appellate Committee each analysed the case in a slightly different way. Some saw the case being about ultra vires, some about irrationality. And like Mr. Strawn, I'm conscious that the course has been taken to it in some detail in recent weeks. Can I just give you some of the references to the key passages? I hope that that's helpful. Lord Fraser thought the case was about whether or not the Secretary of State had acted ultra vires. Lord Fraser's was an ultra vires analysis, 1995 by letter E. Lord Scarman thought the case turned on whether the respondents were exercising a statutory discretion in an unreasonable way. And Lord Scarman's analysis would be that the guidance would be unlawful if it permitted or encouraged unlawful conduct. And for your note, 2012 letter E to 2013 letter F. Just one can be clear. It cannot sensibly, Lord Scarman's judgment cannot sensibly be read as one that says the error only arises if there's a misstatement of law on the guidance. in the guidance. What Lord Scarman was looking at was what's the legal consequence of the guidance. Lord Bridge thought this couldn't be a case about unreasonableness because there was no specific statutory background. Said that it held that at 2024 letters B to G. But Lord Bridge said the court could intervene if the document disclosed a mistake of law. See 2025 letter G to 2026 letter B. Lord Brandon, in dissent on the question of the underlying legality of providing advice without parental consent, applied a ultra vires analysis and asked whether a policy that promoted, encouraged, or facilitated unlawful acts could be interpreted as being permitted under the Enabling Act. And my lords will have that at 2029 G to 2030 C. And finally, Lord Templeman, although reaching a different decision on underlying legality to Lord Bridge, shared his view that this wasn't contrary to Lord Scarman's assessment about unreasonableness, but rather a mistake of law. So 2038C to 2039A. So we have a range of decisions. We have Lord Bridge and Lord Templeman saying mistake of law on the face of the document. We have Lord Scarman, irrationality, Lord Fraser, ultra vires, Lord Brandon, ultra vires. Now, fortunately, we say I don't have to justify one analysis and distinguish another, because the respondent's case we submit is readily understandable as falling within all of them. Guidance which permits actions which are not authorised by the relevant statutory scheme, or create outcomes that are prohibited by the statutory scheme, or create outcomes that are themselves unlawful, a fortiori in breach of fundamental rights, are likely to be ultra vires and irrational, my Lord of Sales.
Yes, I mean, in that formulation, quite a lot turns to what you mean by permits unlawfulness, doesn't it?
Yes.
Because there's nothing in this guidance that says, well, if you think you've got someone who's aged 17, treat them like an adult. It might be said that this guidance is specifically aimed at trying to get the officers to apply the statutory test correctly. Is that not a fair characterisation?
Well, no, my lord, what it's doing is telling an officer that if, in your view, someone who looks 23 is significantly over 18, you should treat them as an adult. So it is, therefore, causing an unlawful act.
But I mean, that in some ways takes me back to a point I've pressed on already, and I don't want to take up too much time on it, that it's the underlying statute that, in a sense, causes the unlawful act, because it sets up a point of differentiation between two categories. And we just know that sometimes it's difficult to apply that, but officials do have to apply it.
Well, but it's a very hard-edged decision, we say, my lord. It's a decision that the Secretary of State is required to take, because the Secretary of State is prohibited from detaining children. The Secretary of State is not prohibited from releasing adults. There's a one-way street in respect to the statutory prohibition. And we say the Secretary of State is obliged to provide guidance to her officials to ensure that that statutory prohibition is met and enforced. And the heart of our case is the manner in which she has done so generates unlawful decisions, because the decision maker under the policy is able to reach a decision that someone who is a child but nevertheless looks 23 should be treated as an adult.
Yes,
well, look, that is the heart of that is the beginning and the end, really, of the case.
Yes, I rather thought that it might be. Yes, thank you.
Of course, my lord, there's just to make, if I may just say so, if I may state the obvious, the statute doesn't require an age assessment. There's no, I beg your pardon, it doesn't require a test based on physical appearance and demeanour. That's just the means by which the Secretary of State has chosen to comply with her statutory obligations.
I'm not quite sure I follow that, because I thought we were all agreed that there will be some cases where the statute has to be applied and the only evidence is appearance and demeanour. There just is nothing else.
Well, my lord, under the system that the Secretary of State has devised, I mean, there could be a range of different systems, some of which, of course, may have more practical implications. But the Secretary of State, if the Secretary of State wanted, could have social workers carrying out film urgent assessments of courts. I mean, doubtless that would be very expensive and impractical. The point I'm meaning to take is there's no statutory requirement this be dealt with in this way. This is the way the Secretary of State has chosen to do it. It comes with problems because of the inherent unreliability of it. Those problems are magnified and amplified by this aspect of the impugn policy, because they lead to children being unlawfully detained, because there will be children who are 23 and who look as though they're 23, and there is nothing that stops, in compliance with the policy, an immigration officer considering they look significantly over 18 and therefore detaining them as a child.
Yes, thank you.
So, my lord, I was just dealing with Gillick, and I was suggesting that whatever formulation one takes, we would fall within it, because it's hard to see how a policy which we say causes those unlawfulness, contrary to a statutory provision, could be held intra vires, and it's equally hard to see how a policy which results in unlawful deprivation could be deemed rational. A fortiori, now that we know it can be operated in a way that does result in correct or unimpugned decision making, that doesn't result, so far as we know, in unlawful acts. Now, there may be cases in which there is a fruitful debate to be had between distinguishing the precise meanings ascribed by Lord Scarman to permitting or encouraging unlawful conduct, or those identified by Lord Brandon of promotion, encouraging and facilitating. But we would submit that on the facts of this case, where the good faith application of a policy by the immigration officer can be the direct cause of an unlawful detention, the position is tolerably clear, whatever word you use. And it's helpful, we say, to see the formulation adopted by Galbraith, by Mr. Justice Green in Letts, which conveniently we say and accurately summarises the tests. My lords will find Letts in volume 1, tab 16, page 2275.
Mr. Hermer, hasn't Letts been qualified by the Court of Appeal in Bayer?
Yes, my lord. I was just going to come on to that afterwards to give Lord Justice, the Vice President's treatment of it. I was just going to show you Letts
particularly in relation to the word permit.
Yes, exactly, my lord. Yes. So if we could start at 2307. We can see that his lordship begins at paragraph 13 by drawing together some conclusions that the guidance was predicated on legal errors. His lordship then moves from paragraph 114 to Gillick, setting out the two speeches of Lord Templeman and Lord Bridge. It's unsurprising that his lordship is relying on those two speeches, we say, because they're the ones that deal with legal mistake on the face of the document. He then moves to Tabac, which is not a case about legal error, it's a case about a systemic, what was said to be systemic unfairness. he notes at 17 that counsel for the Lord Chancellor accepted. I beg your pardon, I should just show you Gillick at 116. There's the citation in the judgment of Lord Justice Richards, which says, you can see from Gillick, just by letter E, followed would lead to unlawful acts or decisions which permits or encourages such acts. And we can say that that's suggested that that might have been a gloss to the formula used in Gillick. In fact, it's not. It's the precise formulation used by Lord Scarman.
So where do you find that reference, Mr. Hammer?
So, my lord, it's in paragraph 116 of Mr. Justice Green's citation of Tabak. So you have paragraph 116, page 22309. At paragraph 117, you can see that it suggested that Lord Justice Richards in Tabak had added a gloss to the formula used in Gillick, which permits or encourages. In fact, it's not a gloss. That's the formulation used by Lord Scarman. Thank
you.
So on any view, it's a fair and accurate encapsulation of the test. And then at 118, the test is, would the guidance, if followed, lead to unlawful acts, permit unlawful acts, or encourage such unlawful acts? And then there is, of course, Bayer, which is Authorities 28 at EF 2690, and the judgment of the Vice President at paragraph 96 in particular, and at paragraph 200, where you see some insights on how permit is to be understood, so that it means sanction or positively improved. Well, my lord, we submit that we comfortably fall within any of these definitions. This is a policy that, when applied properly on its face and in good faith, leads to children being unlawfully detained, because decision makers can reasonably, under the face of the policy, unaware of the margin of error that they should be taking into account with this decision, can perceive people who they think significantly can deem people who they consider to look significantly over 18, but are in fact, because they look 22 or 23, but are in fact children. On any of the phrases used in Gillick or Letts or Bayer, we say they are all of application here.
The word used in Bayer is sanction, I think. Can you say that this guidance sanctions the particular result when it all seems to be directed against achieving that result?
Well, my lord, yes, because sanction can't be read to provide a bright line test that has any principled basis, that permits you to identify the cause of the unlawful detention being the application of the policy. But because the policy didn't tell you in terms that's what you were supposed to do to produce an unlawful outcome, it's somehow lawful. There's no principled, we would submit, basis for reading those words. The real question is it causing the unlawful outcome? Is it? Lord Sales.
Yeah, just following up that point, isn't the point being made by the Vice President in that paragraph 200, when he talks about using the word, interpreting the word permit as sanctioned, that one is looking for a normative statement in a policy saying that a particular result is to be encouraged or is to be permitted, whereas, as it seems to me, arguably at any rate, you are eliding that concept with a causation concept of causation in fact. And you seem to be saying that it's enough if in fact a policy might, when applied conscientiously in accordance with its terms, have certain consequences, even if it's not encouraging or sanctioning an official to misapply the law.
Well, we would say
I wonder
properly.
how you react to that.
Yes, because my lord, we say that that properly understood, what's going on is sanction. It's not saying please do detain people who are 23, even though they might be 18, but the effect is exactly the same. And to draw a distinction between one being unlawful in public law and one being lawful in public law, it would be an unreal test. You look as to what the effect of the policy is when implied as intended. If a policy is leading to the unlawful detention of children, the power of the court to intervene does not depend upon whether that was an intentional and explicit intent of the policy, or one that is the inevitable result of it.
Yes, thank you.
In Gillick didn't tell the doctors that they had to provide contraception to children. It allowed the possibility of it. It wasn't positively promoting it. To the contrary. Now, the appellant's argument on Gillick are much more confined. Our argument is that Gillick and the subsequent authorities can only apply if the policy guidance contains an explicit erroneous statement of law. And that submission, which is their primary submission, and as we now understand it under Gillick, is misplaced for at least two reasons. Firstly, as I identified, it's only Lord Bridge and Lord Templeman who identified the relevant public law wrong as being the promulgation of legally erroneous guidance. But even here in their judgments, there is nothing that suggests that the impugned document must proclaim an explicit but erroneous proposition of law. It's sufficient that it leads the decision maker into legal error. And for the reasons I've just given, any other analysis would be legally illogical. If the application of a policy creates an unlawful outcome, why could it possibly matter whether the policy is an expression of a legal proposition rather than a mandate to apply a test that leads to the same unlawful result? It would be illogical and without principle. And secondly here, the policy can in any event be construed as expressing a mistaken law. In Gillick, leaving the question of parental consent to clinical judgment of doctors was considered by Lord Templeman to be a mistake of law because it presumed they had a lawful basis in exceptional circumstances not to consult. So here, the policy contains a mistake of law, namely that if an immigration officer holds a reasonable belief that a person's appearance and demeanour strongly suggest they're significantly over 18, they're entitled to detain them under the 1971 Act. That can't be right, because the significantly over 18 can include people who are children, the reasons I've said now on a number of occasions. So that's why we say we're within classic Gillick grounds, why this case concerns ultra vires and irrationality. Can I turn to the fourth heading, which is the criterion to be applied to determine whether or not there's been illegality? And we accept that the mere theoretical possibility that a policy might lead to an unlawful outcome does not always mean that it's amenable to judicial review. Sometimes a document will be no more than non-binding guidance that a decision maker will be free to ignore. Sometimes when the document is properly construed, the chances of an unlawful outcome are remote or can be readily explained by individual error. On other occasions, the subject matter will be sufficiently slight that the court may feel granting relief is not appropriate. But this case falls to the other end of the scale. It concerns a policy that, although not a law in the strict sense, is a mandatory instruction to a state agent which bears directly on the liberty of a child with potentially profoundly detrimental impact on their physical and mental health. it's a case in which evidence shows not simply that a considerable number of children have been unlawfully detained as a result of this policy, but provides an unchallenged analysis as to why that has occurred because of the failure to take into account the margin of error. Now, the identification of the legally significant threshold does not actually require proven cases of illegality arising out of the application of the policy. Depending on context, a court is entitled to take a realistic view in the real world as to whether the policy is likely to give rise to illegality, sufficient to render it void ab initio without the need for actual examples of it producing illegality in practice. We say that insight into that approach is given by this court in Unison. Our Lords will find Unison in Volume 1, Tab 23, 2455, electronic, and I was going to take, my Lords, straight to paragraph 90 in the Judgment of Lord Reed, which is at page 2489. And at paragraph 90, my Lord turns to whether the fee order effectively prevents access to justice. And you can see from the second sentence that it was argued by the Lord Chancellor that fees cannot be unlawful unless it's proved that they have prevented access to justice in specific cases. No one has given evidence in these proceedings that they were unable to bring a claim because they could not afford fees, and then some further arguments on behalf of the Lord Chancellor are set out. And then my Lord at paragraph 91 said this: in order for the fees to be lawful, they have to be set at a level that everyone can afford, taking into account the availability of full or partial remission. The evidence now before the court, considered realistically and as a whole, leads to the conclusion that the requirement is not met. In the first place, as the review report concludes, it's clear there's been a sharp substantial fall in the volume of cases. And whilst the review fairly states there's no conclusive evidence that fees have prevented people from bringing claims, the court does not require conclusive evidence. As the Hillingdon case indicates, it's sufficient in this context if a real risk is demonstrated. And the reference there to Hillingdon is the reference to the decision of Lord Justice Dyson. And I just give you for your note, that's tab 11. And we anticipate the paragraphs that the court had in mind were paragraphs 60 to 61 in the judgment of Lord Dyson. That's EF 2187, where the court stressed that the impact of an impugned instrument, there also a fees order, needed to be considered, as the court put it, in the real world.
But the important point, Mr. Hammer, that one needs to bear in mind in relation to Unison, which was discussed earlier in the judgment, was that in order for there to be an unlawful, in order for the fees order to be unlawful, it wasn't necessary that they actually prevent people from bringing claims. What was unlawful was an impediment or hindrance to access to the tribunals. And in that particular point, if you go back to paragraph 78, where it said that impediment, yes, most of the cases that had been cited up to that point in the judgment were concerned with barriers to the bringing of proceedings, but impediments, which was the word used, for example, by Lord Diplock in the Times newspaper's case in paragraph 77, and also, yeah, that's the expression he used. Impediments can constitute a serious hindrance, even if they don't make access completely impossible. And then various examples of that are given. And so that's the context in which it was sufficient that that the fees presented a real risk that people would be unable to bring claims, because in those circumstances they would constitute a hindrance, and that would be sufficient to render the statutory instrument ultra vires in the absence of authority to impose that kind of hindrance.
Yes, my lord, and of course, my lord, we accept that, and indeed, to some degree, as I'm going to develop. Oh, I'm so sorry, my lord.
So it's I think the difference from your case is that you're saying it's enough to show a real risk of an unlawful outcome, whereas in Unison, the unlawfulness was demonstrated by the existence of a real risk of people being unable to bring claims.
Yes, but which my lord, as my lord put it in paragraph 87.
Right. I hasten to add that the author isn't necessarily the best interpreter of it.
But my lord, we say with the greatest of respect that actually the comparison between Unison in this case is apt. In that case, there was essentially a hard-edged unlawful outcome, which is there an impediment to justice? In this case, there is equally a hard-edged unlawful outcome. Is the policy leading to unlawful detention? Now, the only distinction that the Secretary of State seems to make is that somehow Unison needs to be confined to cases about access to justice. That I'm afraid is illogical and a distinction without any principle. The essential ingredients of the cases are the same. Does the impugned instrument lead to unlawful outcomes that have not been sanctioned by Parliament, or actually in this case it's a fortiori, that have been expressly prohibited by Parliament, and the policy is designed to serve that prohibition? Both cases concern a real risk of breaches of fundamental rights. Now, of course, effective access to justice is a fundamental right, but it's no more so than liberty to the person. And equally, as with access to justice, the protection of the liberty of the person falls comfortably within the constitutional competence of the court. So we say, my lord, the comparison is apt. Does the impugned instrument lead to unlawful outcomes? Now, equally, by contrast, real care has to be exercised with the line of cases relied upon by my learned friend, exemplified by the director of the legal aid case, and the attempt to suggest that the evidential requirements that may be necessary in cases of those nature can be readily transposed to a case such as this. I mentioned earlier the judgment of Lord Briggs. My lord was dissenting on the facts. The majority judgment given by Lord Justice Laws and my Lord Burnett. Can I just show you how Lord Justice Laws put it in that case? Because the contrast with what is appropriate in a case about demonstrating systemic unfairness is very marked from this case. And it demonstrates through contrast why we're in the Unison category, not in the direction of legal aid category. And my lords will find that decision in tab 20. And I was just going to start firstly to show you the nature of the challenge from paragraph 15 at 2391. So you can see that it's the decision in this case and the cases that were looked at was about the legality of schemes in terms of inherent unfairness and the difficulties that one faces in these cases, and what is required was identified by Lord Justice Laws at paragraph 6, not least adopting the analysis of the Court of Appeal in detention action, which at paragraph 16, 2392, saying that in order to understand whether or not inherent fairness is made out, you need to look at the whole run of the cases. So what's required is a broad evidential sweep. And then insight as to why that's necessary in those cases at paragraph 18, because of the particular difficulty with systems challenges based on unfairness. Because what's very hard to unwrap is firstly, what is the unfairness that's complained of? And then what evidence is really required to do is to enable a court to distinguish between unfairness just because people are operating in a not a particularly sensible way, but yet lawfully, and unfairness that is inherent in the system or the policy itself. Now that's a million miles away from this case, because on this case, one can just take a few reference points, the policy itself and the known margin of error. And that itself gets you there. But in fact, in this case, there was a wealth of corroborating evidence. Not only the statistics that I'll turn to shortly, but also the evidence of experience of people in the field. And vitally important, it may be thought, if one doesn't need to look at the evidence, the concession recorded by the Court of Appeal that in innumerable cases, age assessments are wrongly treating children as adults. So, my lords, for all those reasons, we say that the real risk test of a more than insignificant number of impacting on a more significant, on a more than insignificant number of unlawful outcomes, which in the context of detention of children is going to be a very low figure, was the correct test to apply here. And the Secretary of State was entirely correct to accept before the Court of Appeal that was the test that should apply. And it's very difficult to divide from my learned friend submissions we submit what the actual test says should apply. My lord, policy, the simple and short point is that if the guidance is ultra vires, and if it is held to be not only ultra vires but irrational because it leads to unlawful results, then the underlying rationales for why that policy has been fixed become irrelevant. Just as necessity is no defence in a private law claim of private unlawful imprisonment, nor can it be a justification with any legal footing for a scheme that is ultra vires. My lords, I was going to turn then, if I may, that's all I was going to say about ground one and what the appropriate test was. I was going to turn briefly to ground two to say why the Court of Appeal got it right. And I was going to stage my submissions on that through two staged questions. The first was to ask whether all the members of the court were right and justified in reaching their conclusions in respect of the policy before the upper tribunal. And secondly, whether the changes wrought by the amendments by the time of the Court of Appeal hearing undermined the conclusions of the majority that it was still unlawful. I was going to just take it in that way, if I may. Can I just give you the references to where you'll find both policy documents that were before the upper tribunal? You'll find actually all the relevant sections are in fact set out in the judgment below. Paragraph 17 to 20 gives you the EIG, page 177, and all the relevant extracts of assessing age are at paragraph 25, 181. Can I just make 4 points highlighting features of the majority and the analysis of the court? We say, firstly, they were correct to note that whilst it is not illegitimate for the appellant to have a system that relies on immigration officers conducting assessments having regard to appearance and demeanour, it was also incumbent on her to ensure, insofar as possible, the decisions took into account the inherent unreliability of that methodology and the unchallenged evidence of the very significant margin of error. And we can see that at paragraph 57, page 192. 56, having noted it can't be illegitimate for the Secretary of State to have in a system that is not as rigorous as Merton, the Vice President said that's only half the story. If it is legitimate to make an initial decision based on appearance and demeanour only, it's incumbent on him to ensure, so far as possible, that such decisions take fully into account the wide margin of error which such decisions will necessarily involve, so that only those young people who claim to be under 18 are obviously false are detained. My Lord, we say that must be right in the context of a decision bearing upon the potential unlawful detention of a child and a clear statutory prohibition. If you're going to impose, you're choosing a system, might be for very good reasons, based upon appearance and demeanour, that you know is inherently unreliable, plus, in particular, you know that there is a margin of error, it's all the more important to make sure your policy addresses it. Second point is that paragraph 64, His Lordship acknowledged at 195, acknowledged that there were safeguards built into the policy documents, but as we see from 65, which we've already looked at today, which is one of the key passages in the judgment, at 65, said that it failed in one key respect, a failure to take into account the margin of error. And His Lordship returns to that at 67. The criticism is the guidance fails to convey just how doubtful an assessment based on physical and appearance demeanour alone is, and the width of the margin of error that is consequently required. Third point is His Lordship was able to reach his conclusions without specific evidence of cases of unlawful outcomes. And we can see that at paragraph 68. His Lordship said that this defect in the policy guidance gave rise to a real risk of children being unlawfully detained. That conclusion would be, in my view, justified even without evidence of specific cases where that had occurred. In the absence of guidance on the width of the margin of error, there is inevitably a real risk that immigration officers will place too much trust in their own assessment that a particular young person is significantly over 18. He took, to echo Lord Justice Dyson in Hillington, a real world assessment. Fourth point is that, in fact, although completely justified in that approach, it was corroborated by a considerable body of evidence that demonstrated widespread incidents of children being wrongly identified under the policy as children, being wrongly identified as adults when they were children. Now, that's not just the data, the statistic which I will return to shortly, but it was also the experiences of people who work in the field, such as the Refugee Council, and it was the expressions of concern from expert bodies, such as the Registrar of the Royal College of Paediatrics and the Office of the Children's Commissioner, all summarised between paragraphs 30 and 34 of the judgment. And my lords will find the statements themselves in Appendix Part 2 from EF 1169 onward. And above all, if one needed a ready reckoner to establish the illegality, as noted at paragraph 69, before the Court of Appeal, it was unquestioned that there have been numerous cases where an initial assessment that a young person is an adult has subsequently been found to be wrong. Actually, in the context of the detention of children, nothing more, we submit, was required. The court, as I've said, had much more. Now, I'm going to address the statistics briefly under ground 3, but the Court of Appeal were well aware of the criticisms made by the upper tribunal as to these statistics, and those criticisms in the main focused on the fact that there were 6 data sets of small size. And in respect of
Mr. Homer, when you say you're going to come on to ground 3, bear in mind you're already impinging on Ms. Christie's time.
Oh, I'm so sorry. I'm so sorry. I was assuming wrongly that we were pushing on because we finished. I think Mr. Strawn went into 15 minutes of mine. I'm sorry. That was an impertinent assumption.
No, he did trespass on your time by about 10 minutes because of the technical problems we had. But it's important that you try to come to a close fairly soon.
I shall do that. I shall do, and I'm sorry that I assumed that. And I will. I can wrap up. And my lords, Mr. Strawn didn't deal with ground 3 in oral submissions. It's in our printed case. I won't trouble you. But what I will just say about is that there was a quibble about the percentages used, but not the absolute figures given of of 6 small samples, including 2 from the Secretary of State. And those showed, just within that small sample, that in a 4-year period, there were 63 children who, under the demeanour appearance test, were wrongly classified as adults. And that's just out of the 272 cases looked at. Now, I don't suggest that is an accurate figure that can be applied nationwide, because I don't have to. In the context of the deprivation of liberty of, on any realistic view, the most vulnerable people that there can be, unaccompanied children coming into this country. In that context, however you want to cut it up, those numbers are legally significant. And so we see, taking all those points together, the Court of Appeal were right to reach the conclusions they did in the policy for them. In respect of the, I beg your pardon, the policy before the Upper Tribunal, in respect to the policies before them, can I just simply say this? They were considered in great detail by the Court of Appeal. You can just see that from the lengthy citations in the judgment and in the appendix, and the acknowledgement that they reflect a conscientious attempt to deal with the issues. But the core flaw remained. And that's the point that the Vice President and Lord Justice Baker are alive to. The stress on age and demeanour remains without any identification of the margin for error brought to bear on that decision. The decision makers flicking through the manual, not trained, but flicks through the manual to find out what have I got to take into account when carrying out this test. There's no qualification, and indeed it's worse than that for the reasons I showed you at 777. Positively eschewed any guidance on what might be appropriate for age. And for those reasons, my lord, we say that the majority were absolutely right in concluding that the essential flaws remained untouched, despite the good efforts to improve decision making. And so, my lords, we all say, taking all of that together, the policy is designed to give effect to a statutory prohibition. It's not balancing anything else for these purposes. But in fact, the reasons given by the Court of Appeal, it leads to results that are contrary to the express prohibition, and indeed produces results that give rise to breaches of fundamental rights. And for those reasons, they were right to deem it unlawful. My lords, I'm sorry, and I apologise to Ms. Christie for going over time. Those are the submissions on behalf of the respondent.
I don't think they've lost anything from being somewhat accelerated at the end, Mr. Herber. Thank you very much indeed. Ms. Christie.
I appear on behalf of the Equality and Human Rights Commission, who are very grateful for the opportunity to intervene in this appeal. I rely on the submissions in the Commission's written case, which is at tab 8 of the bundle, beginning at page 137. In the short time I have this afternoon, I wish to firstly address the court on why the Court of Appeal's formulation of the test is appropriate in the present context with reference to a number of cases. Secondly, I'll address the court on the procedural safeguards required by relevant international law for age assessments which bear on a decision to detain. And lastly, on why the Secretary of State's age assessment policy is unlawful and the Court of Appeal was right to find it so. So turning firstly to the test, we say that a test equivalent to the Court of Appeal's formulation has been applied in a number of cases where fundamental rights are engaged. And I'd like to take you to touch on a few of these. Firstly, the Hillingdon case, there was some reference has been made to that. We say this case shows that the real risk test is appropriate where a policy has the potential to harm children. If I can ask the court to just have a look at paragraph 67 of the Hillingdon case at page 2189. We see that this was a rationality challenge, and Lord Justice Dyson, as he then was in paragraph 67, says, I approach it on the basis that the fees order is unlawful if there is a real as opposed to fanciful risk that the increase in fees will result in local authorities not performing their statutory obligations in relation to children who are at risk. So it's clear in my submission that the court was looking at the risk of unlawful outcomes in this case. And I'd ask the court to turn to paragraph 93 at page 2194. At the end of the paragraph, in his overall conclusion, Lord Justice Dyson says that any measure that is said to have the potential to harm the interests of children must be carefully scrutinised to see whether it in fact carries with it the real risk of harm. In the present case, we submit the age assessment does have the potential to harm children where they're incorrectly assessed to be adults and result in the Secretary of State not complying with her statutory duties. And I make the point that this is not an interim policy in respect of children who immigration officials consider to look significantly over the age of 18. These children in those circumstances are at risk of detention. The focus of this challenge has been unlawful detention, but there are also other rights and interests of children which are denied when a child is wrongly treated as an adult. We've set this out in our written case at paragraph 29, page 148 of the bundle. For example, children will be denied their right to education and care, which are entitlements under the Children Act. Children will also be denied important procedural safeguards which are available to child asylum seekers. This is more details are at paragraph 29.3 of our case. But specifically in respect of interviews in the asylum process, children are entitled to be interviewed by immigration officials who've had specialist training in how to interview children. It's highly important for children in the asylum process. But a failure to comply with this, if, for example, an adult is wrongly treated as a child, will not result in the Secretary of State acting unlawfully in respect of that adult. But it will, however, result in the Secretary of State acting unlawfully in respect of a child who's wrongly treated as an adult. And this obligation, which is reflected in the immigration rules, complies with the UK's obligations under the UN Convention on the Rights of the Child, Article 22, and that's set out further in our written case. And as we also say, children who may not be detained, but wrongly treated as adults, will be placed at risk of exploitation if they're accommodated alongside adults. This is specifically highlighted by the UN Committee on the Rights of the Child, and I'll give you the reference for that. It's General Comment number 6, paragraphs 50 to 52, and that's at page 3042 of the bundle. And you'll see at paragraph 29 of our written case, we refer to a report by an anti-trafficking organisation focusing on children in the UK, which addresses instances of children who have been age disputed, inappropriately accommodated, and have then disappeared. Accordingly, we submit that the real risk test, as set out in the Hillingdon case, is appropriate where a measure has the potential to infringe the rights of children. And we would say that the risk here is not one that's created by the statutory prohibition on the detention of children. It's created by the choice of the Secretary of State to allow immigration officials to assess age, rather than, for example, simply allowing the assessment of age to be conducted by social workers. In respect of this, I would just note that in the respondent's written case at paragraph 37, that's page 117, you'll see that the Secretary of State originally considered that that would be an option. And the risk, in addition to being created by the Secretary of State allowing immigration officials to assess age, it's also created by the choice of policy test, which permits immigration officials to assess age by way of physical appearance and demeanour, without, I'll come on to address this further, without properly incorporating the known margin of error into that assessment. The next case I wanted to touch on is the Munjaz case. The court will be familiar with that case. I want to make 2 points in respect of it. Firstly, although the language of significant risk was used, we submit that there's no substantive difference between this test and the real risk test, and I'd just like to give the court a couple of references in respect of that. In the judgment of Lord Bingham at paragraph 29, page 2142, Lord Bingham also uses the language of material risk, and in the judgment of Lord Hope, paragraphs 80 and 81, page 2159, as well as explaining that the test is a significant risk, he also uses the language of serious risk. And my second point in respect of this, Mr. Strawn rightly says that this case was a case about positive obligations. The significant risk test was formulated having regard to the positive obligation inherent in Article 3 to protect against a breach where it's known or ought to be known as a risk of a violation. And you see that in paragraphs 77 to 78 of Lord Hope's judgment. But in my submission, this test shouldn't be confined to Article 3 cases, because Article 5 also contains a positive obligation to take appropriate steps to protect individuals from being unlawfully detained, where a state is aware or ought to be aware of a risk of violation. I'm afraid the cases aren't in the bundle, but I can give the court some references for this, and I'm very happy to provide the copies of the cases subsequently. But in the case of Stork against Germany, 2006, 43 European Human Rights Reports, number 6, at paragraphs 101 and 102, the court makes clear that the positive obligations to protect against an interference either by state agents or by private parties, which inhere in Articles 2, 3 and 8, also inhere in Article 5 of the Convention. And this is endorsed by the Grand Chamber in the case of El Masri against Macedonia, which is 2013, 57 European Human Rights Reports 25 at paragraph 239. And in my submission, it's undeniable that there is a risk that decisions on age, which have a bearing on detention, may lead to a violation of Article 5, and thus the protective obligation arises. So in our submission, it would be appropriate to apply the Munjaz test and do what the House of Lords did, look at whether the policy as a whole and properly operated gives rise to a material risk that children will be unlawfully detained. And we say that is in essence the same test as the Court of Appeal applied, simply that in Munjaz they got there by way of positive obligations. Finally, on the test, I'd just like to make a few points in respect of the test used where convention rights are affected. We see the test most recently very clearly set out by Lady Hale and McLaughlin, and also articulated by Lord Mance in the Northern Ireland Human Rights Commission case. Is it bound to, will it inevitably operate incompatibly in a legally significant number of cases? And in respect of this language, we submit that the language of inevitability and bound to signifies that the risk of unlawful outcomes must be inherent in the structure or terms of the legislation or policy itself, so that you can identify a cohort who risk being affected, but it doesn't mean certainty. And we see that in the case of Bibi. In that case, the court found that the immigration rules themselves were not unlawful. But when it came to the guidance, we see Lady Hale, I'll just give you the reference, she uses the language of likelihood at paragraph 54, which is page 2372. She says that there are likely to be a significant number of cases in which the present practice does not strike a fair balance. And because of that, the guidance needed to be recast. Again, at paragraph 60, 2373, page 2373, again, she uses the word likely. And Lord Neuberger, paragraph 77, page 2377, says that the guidance seems to be bound to. And so we say this is not language of certainty. And in substance, there's very little difference between the language of real risk, likelihood, bound to, inevitable. These exercises are forward-looking, they're predictive. They require something inherent in the policy, which gives rise to interference with a particular cohort. And finally, on the formulation used by the Court of Appeal, more than a minimal number, we say this is the same as a legally significant number set out in McLaughlin. Both tests require that the risk be a material one rather than a theoretical or remote possibility. And what constitutes a legally significant number will vary depending on the context. And in this case, we have a statutory prohibition on the detention of children, and we've set out in our written case the very severe consequences for children who are incorrectly assessed to be adults. So in my submission, this is an appropriate test to be applied. It's in essence the same test as that applied by the Court of Appeal. So those are my submissions on the test. I'd like to move on to the second issue, which are the procedural safeguards required by relevant international law for age assessments which bear on a decision to detain. We submit that the Secretary of State's policy did not comply with the procedural safeguards required by the ECHR, the UN Convention on the Rights of the Child, and EU law, which was in force at the time of the Court of Appeal's decision. And this is an additional reason why the policy is unlawful. I'll address you first on Article 5. Article 5 protects the right to liberty. As we know, detention is permitted under an exhaustive list of circumstances. And you can see the text of Article 5 at page 1937. And detention for immigration purposes is permitted under Article 5(1)(f) at the bottom. However, to avoid a breach of Article 5, detention has to be lawful. And this means that it must be permitted by domestic law. So any detention which is unlawful domestically is ipso facto a breach of Article 5. But it also imports a requirement that detention must not be based on an arbitrary procedure. And this means that the procedure for assessing whether a person falls within a category of persons who can be detained under Article 5 must be a reliable one. And we get this from the case of Winterwerp against the Netherlands, which is Authorities tab 31, and it starts at page 2839. And I'd like to ask the court to turn to page 2853. Paragraph 37 starts on that page. And at the very bottom, it says Article 5 sets out an exhaustive list of exceptions, goes on to say that the object and purpose of Article 5 is to ensure that no one should be dispossessed of his liberty in an arbitrary fashion. And then at paragraph 39, further down the page, the court goes on to look at the question of lawfulness. In that case, it was under Article 5(1)(e), but the principle applies to all of the permitted grounds of detention within Article 5. If I can ask the court to turn over the page, page 2855, we see the third paragraph down, no detention that is arbitrary can ever be regarded as lawful. And the Commission had emphasised that there should be no element of arbitrariness. What that meant was that a person couldn't be detained on the basis of being a person of unsound mind in the absence of medical evidence confirming this. Halfway down the page, we see the court fully agrees with this line of reasoning. a person should accept an emergency, an individual should not be deprived of liberty unless he's been reliably shown to be in unsound mind. So in my submission, Winterweb shows us that for detention to be non-arbitrary, the determination of whether a person falls within a category of permissible detention must be made on a reliable basis. And what that means in the present context is that the process for determining whether an individual is an adult who is detainable or a child who is not detainable must be reliable and non-arbitrary. But irrespective of the statutory prohibition, Article 5 also requires a reliable process for assessing age because it includes a requirement that children who are detained under immigration powers only be detained in conditions which are appropriate to their age and their vulnerability. And this is clear from the case of Mayeka and Belgium, a Grand Chamber decision, which is in the bundle. I'll just give you the references. At paragraphs 103 to 5, page 2899. In this case, the Grand Chamber found a breach of Article 5 where a child was detained alongside adults. In that case, the child was very young, just 5 years old, but the principle applies to older children as well. And we see that in the case of Abdullahi Elmi against Malta. And at paragraph 111, which is at page 2979, the court made it clear that Article 5 requires conditions that ensure children receive proper counselling, education, and age-appropriate entertainment facilities. In that case, the applicants were 16 and 17 years old. And the court found both a breach of Article 3 in respect of conditions, but also a breach of Article 5. And that's page 2987, paragraph 147. So if children are treated as adults on the basis of an unreliable and thus arbitrary test, they will also be detained in inappropriate conditions in breach of Article 5, irrespective of the domestic statutory prohibition. I'll come on to address you on why we say the Secretary of State's policy doesn't satisfy the Article 5 requirement to ensure that decisions on whether a person falls within the category of permissible detention are taken on a reliable basis. But I'd first like to address you on the procedural requirements arising from the best interest obligation towards children. You've been taken to Section 55 of the Border Citizenship and Immigration Act already. This incorporates the UK's obligations under the UNCRC and is known as the best interest obligation. I'd like to just take the court to the statutory guidance issued under Section 55. It's at page 4495 of the bundle. And if you can turn to 4497, paragraph 2.6 at the bottom of the page, it says the UK Border Agency acknowledges the status and importance of the following and lists a number of international instruments. And on the following page, you'll see at the top mention of the UN Convention of the Rights of the Child. And it says the UK Border Agency must fulfil the requirements of these instruments in relation to children while exercising functions as expressed in UK domestic legislation and policy. I want to highlight the procedural obligations inherent in the best interests obligation, as explained by the Committee on the Rights of the Child. Now, their views are not binding on the court, but they have been recognised by this court as the authoritative international view of what the UNCRC requires. And I have references to the Williamson case and other cases making a similar point. They're at paragraph 9 of our written case, page 139. So I'd just like to highlight a few points made by the committee, both in its general comments and recommendations specifically to the UK. Firstly, that the concept of a child's best interest is aimed at enjoying the full and effective enjoyment of all the rights in the Convention. We get that from General Comment 14, paragraph 4. The reference is at page 3056. And we say that a necessary step in ensuring the protection of children's rights is the identification of children as children. And General Comment 14 also makes clear that states are required to have strict procedural safeguards and transparent and objective processes for all decisions made by administrative authorities which impact on children. And this is paragraph 87 of General Comment 14, page 3071. And this, we say, is why it is that the Secretary of State is obliged under Section 55 to promulgate a policy in circumstances where she's permitting her immigration officers to conduct age assessments. The CRC has also explained what is required in age assessment processes, and I'd like to ask the court to look specifically at 3 references. Firstly, General Comment number 6 was issued in 2005, and the reference is page 3037 at paragraph 31, Roman numeral 1. The court can have a look at that paragraph. The committee makes clear that age assessments must be conducted in a scientific and fair manner. They should accord the individual a benefit of the doubt, such that if there is a possibility that the individual is a child, she or he should be treated as such. That's what the principle of the benefit of the doubt means. In its 2016 report to the UK, this is a report specifically on the UK, it's at page 3105. The committee expressed concern about the detention of age-disputed children and recommended, and we see the recommendation is over the page at paragraph 77, C, recommended that the UK conduct age assessments only in cases of serious doubt through multidisciplinary and transparent procedures. And finally, I'd like to ask the court to look at General Comment 23, which was issued in 2017. That's at page 3089. And age assessment is dealt with at paragraph 4. The committee there emphasises the importance of a comprehensive assessment by professionals who are skilled in combining different aspects of development. You see halfway through the paragraph, the benefit of the doubt should be given, and states should refrain from using methods which may be inaccurate with wide margins of error. So in summary, what the Section 55 obligation requires is that where the Secretary of State is going to permit immigration officers to undertake age assessment of individuals claiming to be children, the Secretary of State is required to have a transparent and objective procedure for doing so. And the policy must give proper effect to the benefit of the doubt. And what we say that means is that if there is a possibility that the individual is a child, she or he should be treated as such. And we say that the policy doesn't do this, and I'll come on to address you further on that. We've made submissions in our written case as to the requirements of EU law, at paragraphs 21 to 24, pages 144 to 145 of the bundle. These requirements, we say, are consistent with the obligations that arise under the ECHR and the UN Convention on the Rights of Children. Essentially, age assessments must be undertaken using objectively reliable methods to avoid arbitrary detention. And we say that EU law is relevant insofar as this court is looking at whether the Court of Appeal erred in finding the policy to be unlawful. And we say that the policy also breached EU law obligations in force at the time, which were binding, and that Lord Justice Baker was right to find it was unlawful on that basis. And you'll see that in Lord Justice Baker's judgment at paragraphs 103 to 5, pages 203 to 204 of the bundle. So my final point, I'll move on. We say that the age assessment policy is unlawful. We rely on submissions in our written case. But in summary, we say the policy doesn't satisfy the procedural requirements of Article 5. It doesn't satisfy the requirements of the UNCRC as given effect in the Section 55 duty, or the requirements of EU law. It's based on a notoriously unreliable method of assessment, founded in stereotypical notions of what a person should look like at a certain age, which is carried out by immigration officers who receive no specific training in age assessment process. And we've set out at paragraphs 26 of our written case the view of the courts tasked with making judicial determinations of age. And at paragraph 27, we contain references to the views of the Association of Directors of Children's Services guidance, which similarly holds the view that assessment based on physical appearance and demeanour is unreliable. We say that the test doesn't properly incorporate the known 5-year margin of error, and as such, it doesn't give proper effect to the principle of the benefit of the doubt. And we would adopt what Mr. Hermer has said in respect of the reference to the margin of error further on in the policy in respect of paediatric reports. There is nothing in the policy, we say, that directs immigration officers who are conducting an assessment based on physical appearance and demeanour as to the known margin of error that should be applied. And as such, the policy allows persons who may be of an age falling within the margin of error to be treated as adults, notwithstanding the very real possibility that they're a child. For those reasons, we submit that the Court of Appeal was right to hold that the policy was unlawful. And we respectfully remind the court that children who are incorrectly treated as adults face very serious and harmful consequences, which we've set out in paragraphs 28 to 29 of our written case. And we would adopt the view of the Association of Directors of Children's Services in respect of the dangers of incorrectly treating a child as an adult. Their view is set out in their age assessment guidance at page 4532 to 4533, where they say that the dangers inherent in treating a child as an adult are in almost all cases far greater than the dangers of taking a young adult into care. And for all those reasons, the Commission would respectfully invite the court to dismiss the appeal. Those are my submissions, unless I can assist the court further.
Thank you very much, Ms. Christie. We are very grateful to the Commission for its assistance, and we're also grateful to you for keeping to your time. Mr. Straw.
My Lords, thank you. I'll try and be very brief in reply and just address a number of miscellaneous topics, if I may. The first was as to the nature of the policy itself, whether it was made under common law or statutory provisions. And that arose from a question originally from my Lord Lloyd Jones. I gave the answer that it's not made pursuant to section 55(3) of the 2009 Act, and that is correct. Indeed, the statutory guidance that is made under that particular provision is the guidance to which my own friend Ms. Christie took the court to a moment ago, E4495. And moreover, the age assessment policy that the court's looking at refers immigration officers to that guidance, that statutory guidance. See page electronic bundle 772 in the age assessing policy. The second matter concerns Lord Reed's question regarding Mr. Justice Stanley Burton's comments in paragraph 1 of the Merton judgment. Just to be clear, I don't think it alters the analysis at all, but the reference in paragraph 1, so far as we can see, was pointing out that anyone under the age of 18 could not be treated as an asylum seeker within the definition laid out in section 18 of the 2002 Act, in the sense that they wouldn't be treated as an asylum seeker for the purposes of part 2 of that 2002 Act. You can, of course, be a child asylum seeker. It's just that those particular provisions wouldn't then apply. But it doesn't alter the general analysis as to the need to determine whether someone is an adult or a child. And in that respect, to see some of the consequences that can arise, can I just refer the court to the upper tribunal decision in this case, paragraph 56, E251, where the consequences of treating someone as an adult rather than a child incorrectly, some of the consequences were specifically identified. The third point is, well, what is the challenge now before the court? My learned friend indicated it's not one of a challenge based on inherent unfairness. And so in that sense, the refugee legal centre line of cases becomes redundant to what the challenge is being advanced. He says instead it's a challenge based on the risk of unlawful outcomes. And we submit that such a challenge is not one a known challenge, nor a legitimate one, to policy of this kind. And the risk of unlawful outcomes, we submit, does indeed, as has been observed in argument, come in fact from the legal distinction operated by the statutory framework between a child and an adult. And what the policy seeks to do is to fully take that into account in the use of the word significantly in criterion C. The purpose of that criterion is not to establish whether someone is 23, 25, or 40. It is to decide whether they're an adult or a child for the purposes of that initial stage of assessment, taking into account the margin of error through the word significantly. And for those borderline cases where there is doubt about whether someone's a child, they are treated as a child for that interim period, pending a fuller age assessment, as the policy makes clear, to resolve that doubt. But where there is no doubt in the officer's mind, because of criterion C, they are treated as adults, and that's not an interim position, unless, of course, it can be challenged. As is apparent and clear from the argument, neither the initial assessments of that kind, nor indeed more detailed assessments, such as those my learned friend Ms. Christie was speaking about under Merton compliance, are risk-free. They can't be, because of the statutory system, which requires the distinction between an adult and a child, and of course that ultimately only being capable of resolution by judicial determination. The policy therefore provides assistance to immigration officers on how to make that determination at the initial stage. And the fourth point to deal with is the suggestion that my learned friend now puts his challenge in a Gillick type way in suggesting that there is some inherent unlawfulness on the face of the policy, or that it permits unlawful conduct. In our submission, when the court revisits what Lord Scarman was identifying, and indeed all the speeches reflect, permits necessarily means that there is a mistake of law that permits, in the sense of encouraging or indeed sanctioning. One has to identify a positive mistake of law, which then causes, in that sense, the meaning of the word permit or sanctioning, the unlawful consequential conduct. That is what is meant by the word permit or sanctions, as now qualified in the Bear case. And if one takes that starting point, you have to identify the mistake of law in the policy, which is then said to permit or sanction the consequential conduct. And of course, here there is no such mistake of law. It is the very reverse, of course. The policy is unequivocal as to the correct state of the law, namely not to detain children except in those exceptional circumstances. And it is all about addressing that position in order to avoid that consequence. And can I just pick up on a point that my learned friend made about Gillick, to the effect that the consequences of the change in the law from the Immigration Act, which means that it is now unlawful to detain, whereas previously one could if one had a reasonable belief, and that somehow changes the lawfulness of this policy. My lords, that's clearly not the case. If you turn to the policy itself, at E704 and at E776, it specifically advises officers of that change in the law, and more pertinently, that even if they do have a belief, a reasonable belief that someone is an adult, if it turns out to be wrong, it will therefore consequently be unlawful detention, and therefore warns them of that consequence. So the policy is entirely directed to setting out a correct statement of the law in order to minimize the opportunity for error. As to the Unison case, my lords, I simply emphasize the distinction between an impugned instrument in that case, which acts as a hindrance of itself to access to justice, in contrast to what is under consideration here, a policy which is intended to further the statutory prohibition of detention of children by avoiding that consequence. The two are completely distinct. And the Hillingdon case, of course, is an example of the former situation, the same situation that arose in Unison, an increase in court fees for public law childcare applications, and whether that instrument consequently had that consequence. And it was analysed as a rationality challenge. See paragraphs 50, 60, 61, 62, and 77 in the bundle 2187. My lords, the other matter that arose was the suggestion that the change to the Act, the 1971 Act, transforms the consequence of detention of children from the undesirable to the unlawful, and that somehow affects the policy. Of course, I've already dealt with the advice in the policy itself about that, but it's always been the case that immigration officers are required to reach the correct view. That's what the policy is directed at. The law doesn't and hasn't changed that. The consequences of getting it wrong are now more severe because of the potential for unlawful detention to arise, but that doesn't change the thrust of the policy. The consequences of getting it wrong are, of course, spelled out in the passages that I've just taken your lordships, just given you the reference to. As to the word significantly as used itself, could I just invite the court at some point just to remind one of what's said in the policy itself at page 779. It specifically talks about the margin of error. It also invites immigration officers to use their own experience of dealing with cases and other determinations. Immigration officers may not be formally trained in age assessments, but of course they will have a considerable experience of making just these decisions, as it's explained in the policy itself. And the second point is the point that Lord Briggs has asked about, the Royal College of Paediatricians guidelines. My learned friend takes exception to us referring to those as somehow new. Can I just invite the court to our written case, paragraph 20, page electronic bundle 66, paragraph 43, and paragraph 144, the electronic reference 74 and 96. We specifically identified for the court the relevance of those guidelines within the policy as a whole, flagging up that advice as to margin of errors in those documents. And my learned friend also raised the question, as does Ms. Christie, of the concept of relying upon physical appearance and demeanour, and the suggestion, well, that's our policy choice. My lords, look again, please, at the Court of Appeal's recognition of the concession made by all parties, paragraph 53, electronic bundle 191. There is no other mechanism at initial stage to assess age other than physical appearance or demeanour. No one is able to identify another mechanism, and full Merton assessments are not possible. My lords, I think I need to finish very briefly, but can I just, so far as the interveners' submissions you've heard a moment ago, I haven't obviously looked at Stork in Germany and El Masri in Macedonia, but my lords, in my submission, they can't alter the analysis. The Article 3 question was about real risk of Article 3 treatment, which is specific. But even if there is some wider test of real risk of avoiding Article 5 detention, none of that addresses the central point as to what risk and how does it arise is an issue. Here, the risk arises because of the distinction between a child and an adult. The policy is directed at reducing the risk of treating someone inappropriately in this context by ensuring officers must be sure of the age of someone as an adult. This is all about cases where there is no doubt in the officers' minds. That's the only circumstances when it applies. And the references my learned friend gave you to the various comments in the materials, the non-binding comments, are all instructive because they emphasize that further detailed age assessments are only required in cases of doubt. They shouldn't be used in cases where there is no doubt. And that's what Criterion C is, of course, about. It's not about detailed age assessments in cases of doubt. And all of those references she gave reaffirm that principle. And the Strasbourg case law is, we submit to the same effect. Article 5, any positive obligation it imposes, and indeed arbitrariness, avoidance of arbitrary results, is all met by this policy, which is actually setting out a very clear principle basis for dealing only with cases where there is no doubt. All other cases, they get the benefit of the doubt, and a more detailed age assessment then follows. There's no suggestion that that process is non-compliant with any of the obligations or indeed comments on those obligations made in any of those materials. For those reasons, unless I can assist the court further, we invite you to allow this appeal for any one or all of the three reasons we've given.
Thank you very much, Mr. Strawn. There don't appear to be any questions. So can I say that we're grateful to all counsel for their submissions. We'll now take time to consider them, and we'll let you have our decision in due course. The court will adjourn.